and I feel daunted here following two exquisite predecessors in their remarks. But I'll try to at least be as good as Cicero was to Demosthenes, who can claim to speak quite with the same eloquence. My focus is on the United States Constitution, and I want to address, I think, some fundamental misunderstandings or misperceptions, and some of them I think are displayed already. And that is, the Constitution doesn't depend upon popular opinion or how many people vote to support X, Y, or Z. If that were true, I'm sure most of our Bill of Rights would not be the law today. And so when we think about ISDS and its constitutional vulnerability under the Appointments Clause, it really shouldn't be formed by how many professors said X, Y, or Z. I mean, professors at one time said blacks had small brains than whites. They can get it wrong. Justice Robert Jackson said in the famous flag salute case that constitutional rights are not subject to public opinion or the outcome of any election. So we need to remember that. We can't be swayed by, well, some people like it, some don't, they want favorite corporations or not, because the issue basically was decided in 1787 when Article 2 of the Appointments Clause said that any official that exercises significant power under the laws of the United States has to be appointed by the President with the advice and consent of the Senate. And if you want to change that rule, then you have to amend the Constitution. And the reason for the rule is not mindless. It says if you have significant public policies under the U.S. laws, they ought to have politically accountable people who are implementing those laws. So in the process of self-government, we can hold those people accountable. The next election, they're appointed by the President. He's responsible as one of his subordinates or for his decisions in that way. I mean, it's an integral part of what we call self-government. That may sound, very highfalutin and unreal and unearthbound with regard to people. They want to make money. Hey, this is trade, and our economy's going to go higher or lower, and it will affect the outcome of the election. But our Constitution isn't about money. It's about liberty and process. It's about the dignity of self-government and following particular rules. Oftentimes I go over to the Chamber of Commerce and try to recite to them Sam Adams, who was kind of the leader, spiritual leader, if you will, of the American Revolution. And he exhorted that, ye who love wealth better than liberty, the tranquility of servitude better than the animating contest for freedom. Go home from us in peace. We ask not your counsel or your arms. Crouch down and lick the hand that feeds you. May your chains rest lightly upon you, and may posterity regret that you ever were our countrymen. So you talk about whether free trade is good or bad for the United States in terms of enhancing our wealth. It's kind of irrelevant to the constitutional provisions. If you don't like the constitutional provisions, you think they're inhibiting maximizing wealth because you don't care about philosophy or liberty, then you have to amend it. You don't get to decree it by popular opinion or otherwise on your own. And we have come to, I call it almost a self-lobotomization of our understanding of the Constitution, that it's not taught anymore, and it's not understood in the White House, certainly not today's White House, in the Senate, in the House. We're talking about the ISDS problem with, you have private individuals interpreting U.S. laws like Article 3 judges who get confirmed and in rendering judgments that are enforced in U.S. courts, and they're not accountable to anybody. And we subcontract out these authorizations. We subcontract out our war power to the United Nations. We subcontract out the treaty power through executive agreements. I mean, one of the elements here, think about this. In 1916, the United States actually resorted to a treaty in order to regulate migratory birds with Great Britain. A treaty requires a 2/3 vote in the Senate to ratify. Very, very high hurdle, because the framers were unified in their conviction that the executive branch would repeatedly sell out the United States on his own without any checks in order to aggrandize his power for pursuing some particular vendetta or to get some equivalent of the Pharaoh's pyramids. So they said, no, this is Alexander Hamilton, who in general was the most articulate defender of a muscular president. He said, we can never trust the president in developing or in negotiating international agreements. He didn't believe in the art of the deal, and he was there at the Constitutional Convention. Therefore, we must have the Senate ratify treaties. So if we have migratory bird treaties, and here we have NAFTA, whose importance to the country dwarfs migratory birds, and it's no treaty. Stunning. I think Bob Bork, I think Senator Byrd at the time was equally astonished that this would not be viewed as a treaty. I'm reminded a similar problem arose with regard to the Iran agreement, which was an executive agreement. This is the nuclear issue. And Secretary of State then, John Kerry, was asked, why isn't this a treaty? All other arms control agreements had been treaties. And his response was, it's so hard to get treaties ratified. He supported a treaty for disability rights, and it got voted down, and he wasn't going to have anything more to do with the Senate. I said, oh, really? Because it's too hard. We're going to cancel elections because it's too hard to win and get voted? I mean, they're truly stunning statements made about the disrespect for procedural regularity. Because we need to remember that these provisions in the Constitution that relate to process, they are the equivalent of what Madison called a structural Bill of Rights. A structural Bill of Rights to protect the American people from tyranny, not to protect the vanity of the three branches and seeing their powers upheld. And that's why the Supreme Court has stated repeatedly, it's not a defense to a separation of powers violation that one branch eagerly has surrendered its power to another. That's irrelevant, because the beneficiary is the American people and the integrity of the process. And if you think the process is flawed, you amend the Constitution. You don't turn it into a homonym. So the words that sound the same, but they mean something different because you've decided popular opinion has changed. Now the reason why maybe my voice is getting louder is because this is like an infectious disease. It is across the board. The war power, the treaty power, executive privilege, oversight power, the Constitution is irrelevant up there. And it's not just the White House, the whole society doesn't even talk about it. It's not in the presidential debates, it's not in the media, nothing. So we have a Constitution that's on life support. And the ISDS is just one symbol about it. Now why do we have it's unconstitutional? The president shouldn't be negotiating it to delete it. He should say it's unenforceable. No one's paying any attention to that. Is it acceptable for him to continue to adhere, even for 1 month or 1 day, to a provision in that's unconstitutional in the NAFTA agreement? Just say, no, I'm out of here. It's invalid. He takes an oath to support and defend the Constitution. He's not bound by what a previous president did. He didn't negotiate the original treaty. The Constitution still is the Constitution today. So that's where we are, in my judgment, on the ISDS. I don't really care about all these arguments, it's pro or anti-corporation or makes us wealthier or not, because that really isn't part of the discussion of its constitutionality. The constitutionality terms on, does this respond to the intent of the framers in insisting that we go through a politically accountable process before we entrust the interpretation and execution of laws of the United States to any particular official? The answer is it's wrong-headed. If you like the general idea, then make the officials who adjudicate these NAFTA disputes subject to the Appointments Clause. There you got it. Moreover, since the United States in general, although it's becoming less so, is the gold standard of due process, where even though we have grave deficiencies post 9/11, that compared to other countries, it's still a model. The other country doesn't want to entrust to our trappings of due process that exceed anything that's in NAFTA. It's too bad. Then they can go elsewhere for their adjudications, but at least for us, we stick to our Constitution. And the fact that we would even have this debate speaks volumes about the marginalization of the Constitution in our political culture and in the fashioning of our laws and treaties.